Hello everyone, and welcome to this week's podcast. Just a short podcast this week as I want everyone to be working on their oral presentations and preparing for the final exam. I think as you all saw with the midterm, multiple choice questions can be challenging. You need to spend adequate time preparing and studying for the final exam. Now, when it comes to international business, one of the most vibrant areas of law in recent history is intellectual property law. You see, intellectual property laws essentially govern the exchange and the use of useful ideas or information. These laws are about protecting the individual or company that came up with the idea, to encourage innovation, to help recover sunk costs, and as a signal to the community of the creativity and the ownership of those involved. Now, such laws have ancient roots in our democracy. Indeed, intellectual property rights were one of the few individual rights spelled out in the Constitution itself, as compared to those added through the Bill of Rights. Article 1, Section 8 of the Constitution explicitly grants to Congress the power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. But traditional IP protections are under a new threat, as the internet has eased the ability to share vast amounts of information over incredibly long distances in a relatively short amount of time. A few simple clicks, and the user gets access, potentially, to vast sources of copyrighted material without any sort of practical restrictions. And viewing and downloading such material is illegal, but the scale at which it occurs is mind-boggling. According to some estimates, common digital piracy sites log almost 150 million visits a day. That costs the entertainment industries worldwide billions of dollars. Now, there are ways you can make money off your IP, and that will be a focus of our talk this week. Licensing is one of the most profitable things that you can do. It doesn't require you to do anything other than to produce your product and then sell or rent the idea to someone else to use, and that person pays you a fee to do so. Now, it does bring up a number of key questions that you want to think about. First is, if you're going to want to sell your IP, you need to ensure that it's protected, that people aren't stealing it for free. And second, you're going to want to make sure that you have protections in place in your licensing and assignment agreements that protect the value of the mark, that maybe allow you to pull the mark back if it becomes abused. Now, in this week's readings, we'll examine the various laws that regulate the use and exchange of intellectual property. We'll look not only at copyright, but also at patent and trademark laws as well. Now, it's important to realize here that not all ideas or creations are protected by copyright or IP rights. Intellectual property only attaches to useful information or knowledge. So while those late-night ideas may seem brilliant to you, they are not automatically protected by copyright laws. And generally speaking, IP rights can be broken down into two different types of categories. The first, artistic property. Those ideas are protected by copyright law. And the second is what we call industrial property, property concerning industrial uses of things. And those are protected by ideas like patent and trademark laws. The lecture book and the text go into details on both. Now, the primary regulation of property rights, or intellectual property rights, is carried out at the domestic level. States have almost all adopted strict rules regarding the protection of IP rights, when such rights are assigned, how, by whom, and how they can be used. Over the last 30 years, we have seen some shift towards international regulation of intellectual property as well. In particular, we see this with respect to the adoption under the WTO framework of the Agreement on the Trade-Related Aspects of Intellectual Property, or TRIPS as it's called. Now, IP laws do try to maintain a very difficult balance. On the one hand, they want to encourage innovation, but on the other, they also have to allow the free debate and free flow of ideas. Consequently, most countries have adopted regimes that allow for the use of copyrighted material in certain instances. In the US, this is referred to as the doctrine of fair use. The idea behind fair use is there are certain times when it might be appropriate to use copyrighted material. And although what is permitted varies between countries, the most common non-infringing uses are the use of copyright material in courts or administrative proceedings. Obviously, to have those function properly, there can't be restrictions on the type of information used. You can use copyrighted material for educational purposes, and in fact, you see me do that throughout the lectures and the books, all using copyrighted material for intellectual purposes. You can also use it for a purely private purpose, although note that computer programs may not be copied regardless of the use involved. And you can use it in brief quotations in scholarly or literary works. You're writing your paper, you quote from somebody, that's allowed. You can even use it in extended quotations of newsworthy speeches or political commentaries. And finally, you can use it in satire. That's, for example, how hosts of late-night TV shows like Jon Stewart, Stephen Colbert, Jimmy Fallon are able to use copyrighted materials to poke fun at it in their shows. Now, as I stated earlier, one of the most profitable things that you can do with an idea or an invention is to sell or to rent it. And we're going to look at the various options that you have to make money off your intellectual property rights abroad. The first is that you may simply decide to work the property rights abroad for yourself. In doing so, the owner is wise to apply for IP protections in the foreign country as well as his or her own state. Second, the owner may transfer or assign the rights to another. This is a permanent divestment of your pecuniary rights, your rights to profit as an owner. If you transfer or assign those rights, it's pecuniary, you've lost everything. If you want to keep something, maybe you just license the rights, which is in contrast to an assignment, usually for a limited period of time set out in the license agreement. Fourth, the owner may establish a franchise and then decide to license the IP to the franchisee. And finally, in certain circumstances, a government may decide to grant what's called a compulsory license, so that a third party may exploit the rights even without your consent. We often see this in cases involving drugs and in developing countries where drug prices would prohibit the drugs from entering those markets and depriving the people in need of those drugs. Often a government will grant a compulsory license to allow for the manufacture of a generic substitute. The lecture book and your text go through all these options in great detail. As I said, I wanted to keep this relatively short, so this is our last substantive chapter together. The final exam is coming up. Good luck. Let me know if you have any questions, and I will see you on the discussion boards.